Welcome back to the video lecture on ASEAN state practice in the domestic implementation of international law. This time, we are going to discuss the matter of the implementation of the ICESCR, which is the Socio-Economic Rights. Of the 22 ASEAN states surveyed, only 4 are not party to the ICESCR. Only Mongolia has ratified the ICESCR optional protocol, while Timor-Leste has signed it. Only 5, the modest states, for example, Bangladesh, Indonesia, Philippines, Sri Lanka, and Timor-Leste, are party to CMW, which Cambodia has also signed. This is the list of the implementation of the ICESCR in Asia. Let me touch upon the SER. SERs are enshrined or read into the constitutions all but 3 ASEAN states, Brunei, Malaysia, and Singapore. SERs are justifiable in 13 of the 19 states whose constitutions protect SER, as this being merely the promotional. The most frequently litigated SER are the rights to education and the right to form or join the trade union, with the judicial recourse available in 10 ASEAN states. From a comparative perspective, the justiciability of the SERs in ASEAN states is substantially below the global average, even if the ASEAN constitutions include SERs within the same regulatory, comparative regional terms. The ICESCR, the committee regularly recommends that the states guarantee the direct applications of the all ICESCR rights within the domestic legal order. The constitutions of the South Asian countries, Bangladesh, India, Nepal, Pakistan, Sri Lanka, all contain at least one justifiable SER, while practice in the 10 ASEAN member states varies considerably. 3 ASEAN states contain no SERs in their constitutions, with the Philippines and Timor-Leste providing for 9 and 12 in their constitutions respectively. Of the 5 Northeast Asian states, the Japan and Mongolia constitutions include 5 and 7 SERs respectively, while China and North Korea and South Korea only provide for many proportional commitments. This is not to say the ASEAN state domestic courts have failed to give effect to specific SERs. One of the academics adopt the tripartite classification of the apex courts approach of certain ASEAN states toward the judicial enforcement of the SERs. The expansive and restrictive and incrementalist. The Indian Supreme Court held that the right to life includes the right of enjoyment of the pollution-free water and air for full enjoyment of life. The Nepal, Pakistan, and Bangladesh apex courts had likewise confirmed a link between the right to life and the third generation solidarity right to health environment. The Sri Lanka Constitution does not explicitly protect the right to life, but its apex courts have guaranteed certain socio-cultural rights by creatively interpreting other rights. It was held that in a case, the Ministry of Industry held that the human beings are entitled to the healthy and productive life in harmony with nature, in finding that prospect the mining agreement violates inter alia the petitioner's constitutional protected civil rights to equality. The same judicial strategy of creatively interpreting the right to life has been applied by the South Indian courts in declaring a right to health, including the right to have water free from pollution and contamination, and the right to livelihood and housing. In the second category, the ASEAN states have been the most selective in the direct enforcement of the socio-economic rights. In China, the right to education was initially recognized in the landmark 201 decision, this was alluded in 208 when the People's Court issued a statement withdrawing its 201 interpretation. In contrast, Taiwanese court in constitutional interpretation number 472 ruled constitutionally a statutory imposed overdue charge in relation to the constitutionally mandated duty to provide compulsory national health insurance for those unable to pay the premium. The state was obliged to provide appropriate assistance and relief and shall not refuse to pay benefits in order to fulfill the constitutional purposes of the promoting national health insurance, protecting senior citizens, the infirm and financially disadvantaged. Invoking non-justifiable constitutional provisions relating to state duties have also been used in Sri Lanka to protect the socio-economic welfare of vulnerable sectors. Although there is no express right to education in Sri Lankan Constitution, which is the call for the universal and equal access to education at all levels from the article in that chapter. The Philippine Supreme Court also have expansively affirmed the concept of intergenerational responsibility insofar as the right to a balanced and healthy ecology is concerned, although such a right is situated in the directive principle chapter in a case challenging the grant of a timber licensing agreement. The court, dismissing the political questions objection, nonetheless noted that so basic, primordial a right did not require positive expression, having existed from the inception of the human mankind. However, other socio-economic rights claimed before the court have received less favorable treatment. The third category, where state adopt the incrementalist approach to justifiability of the socio-economic rights, include Indonesia. In this regard, after initially failing to invalidate a domestic law prioritizing the water resources in a judicial review of the impeached legislation, the Indonesian Constitutional Court has consistently held that the right to the water falls within the article of the Indonesian Constitution, which protects, inter alia, the right to health. It cited General Comment 13 issued by the ICESCR committee to relate the right to water, and also the Article 33(1) of the Indonesian Constitution to the rights of everyone under the ICESCR to enjoy the highest attainable standard of physical and mental health. Thank you very much for your very kind attention.